Hi, everyone, and welcome to episode 23 of Study With Me, European Union Law. This podcast helps you get ready for your university exams and gain a deeper understanding of the subject. Today, we are launching into an essential deep dive for anyone studying the European legal structure. We're tackling, really, a massive constitutional high-wire act.
It absolutely is.
We're talking about reconciling two incredibly powerful legal systems, the supranational order of European Union law, and then the foundational human rights architecture of the European Convention on Human Rights, or ECHR.
And that ECHR system, of course, operates under the Council of Europe, a totally separate body.
Exactly.
And, this is so much more than just academic theory. It's a real test of legal sovereignty. Our focus today is tracing the EU's, let's call it a tempestuous history with fundamental rights.
That's a good word for it.
We'll look at how the Court of Justice of the European Union, the CJEU, was basically forced to invent its own internal system. And it all culminates in the pivotal 2014 ruling, Opinion 213.
The big one.
The big one. It definitively explained why the EU has not yet acceded to the ECHR, despite, and this is the key part, a clear treaty obligation to do so since the Lisbon Treaty.
Okay, so if you're tracking this for your exams, the core question is actually simple, but really profound.
Right.
How did the CJEU manage to ensure that fundamental rights were protected without simultaneously destroying the one principle essential to the EU's survival?
The autonomy.
The autonomy and absolute primacy of EU law. Let's unpack where this all started.
Let's do it.
We begin with what the sources call the initial silence. I mean, you look at the Treaty of Rome, and it's just not there.
Right. It's completely silent on rights. The original focus of the EEC was purely economic integration. Fundamental rights were viewed as almost alien to the project.
Why, though? What was the thinking?
The assumption was simple. National constitutions already did that job. They protected those rights adequately, so there was no need to build a whole new layer of human rights protection into the community framework. It was seen as unnecessary.
In the early CJEU, the Court of Justice, it reflected that view, didn't it?
Oh, absolutely. In the 1960s, as community law started to, expand and actually affect people and businesses, the court took a very, very firm stance.
Which was?
Its job was to apply community law, period. It was not competent to examine or judge EU acts based on national law.
Can you give us a specific case law that really established that initial resistance?
Sure. We have to start in 1959 with Stork. A German company challenged an EC decision, and they based their challenge on their German constitutional rights.
And the court said?
The ECJ flatly ruled it was not competent. It just wasn't their job to look at complaints based on national constitutional law. And they doubled down a year later in Nold.
The first Nold case.
The first one, yes. It reinforced the point, saying the court may neither interpret nor apply national constitutional rules. And crucially, they added that community law itself did not contain a general principle guaranteeing vested rights.
So the court is building this wall, establishing its total independence from national rights norms. But here is where the constitutional crisis, as you said, really starts to brew.
Exactly.
Because at the very same time, the court was defining its absolute superiority over national legal systems. We're talking about the foundational cases every student knows.
Van Gendon-Loos.
Van Gendon-Loos in 63, establishing direct effect, and of course, Costa v. ENEL in 64.
Primacy.
Primacy over all national law, including national constitutions.
And that dual development was the ticking time bomb. The CJEU was essentially saying EU law is supreme even over your national Bill of Rights. But, by the way, we in the EU system don't guarantee those rights ourselves.
Which leaves a massive legal gap.
A huge one, and national constitutional courts saw it as a betrayal of their citizens.
So what was their reaction? How did they try to fill that gap?
They invoked what we now call the counter-limit doctrine.
The counter limits.
Exactly.
Right.
Constitutional courts in major member states, most famously the Italian Constitutional Court in Frontini in 1973, and then, even more dramatically, the German Federal Constitutional Court in Salon-Gessard in 1974.
The so long as judgment.
Right. So long as the EU doesn't protect rights to our standard, we will. They declared that they maintained the right to scrutinize EU acts. If an EU act violated their own fundamental principles, they reserved the right to just declare it inapplicable in their country.
It's hard to overstate how close the ECJ came to losing everything right there. This wasn't abstract theory. This was an existential threat.
Absolutely. If every member state could veto EU law based on its own constitutional interpretation, legal uniformity, the entire basis of the common market, it would just collapse.
So the court was trapped.
Completely. Trapped by its own case law, it had primacy on one side and a lack of rights protection on the other. It was forced to act.
Okay, so to avoid this disintegration of the community legal order threatened by Solange-Ard, the CJEU performs what the sources call a stunning and quite rare change of position.
A complete 360.
They decided to preempt the national courts by embracing fundamental rights themselves.
This was constitutional engineering at its absolute finest. Starting from the late 1960s, the court introduced this solution. Fundamental rights would now be recognized as general legal principles of EU law.
And the court would enforce them.
The court would enforce them against the EU institutions. The very first sign of this shift was in a case called Stouter in 1969.
Which is about butter subsidies, of all things.
Exactly, a very dry topic. But the court used it to quietly introduce this idea that the measure at issue contained nothing capable of prejudicing fundamental human rights enshrined in the general principles of community law.
And that's the critical moment. This is what we call the attraction principle. Right?
That's the one.
The CJEU essentially said, you want a constitutional standard. Great, we've got one. We've incorporated it. Now, if you challenge an EU act, you're challenging it against our internal EU standard, and only we can interpret that standard.
That's the mechanism that defeated the counterlimits. The entire debate, the entire balancing act between EU law and fundamental rights was now happening entirely within the EU legal order.
So by internalizing the rights, the court saved primacy.
It fully preserved the principle of primacy. The validity of EU measures could only be judged in the light of EU law, which neutralized the national court's veto power.
But if these rights weren't written in the treaty, where did the CJEU get them from? Where did they derive the content for these new general principles?
They identified two main sources of inspiration. Firstly, the constitutional traditions common to the member states.
So rights generally recognized across all the national constitutions.
Yes, as they clarified in cases like International Handelsgesellschaft. And secondly, international treaties on human rights. And here, the European Convention on Human Rights, the ECHR, was explicitly cited as a key source in the second Nold case in 1974.
Okay, so for a student revising this, what's the immediate practical consequence of this whole new approach?
The general principles served two major functions. They became, indispensable interpretive criteria for all EU law. But more importantly, they became the constitutional yardstick for assessing the validity of EU secondary law.
Meaning they could strike down laws.
Exactly. Any measure adopted by an EU institution that violated these principles, whether it was about butter subsidies or anything else, could now be annulled or declared invalid by the CJEU itself.
That judicial activism was, incredibly effective, and it eventually led to formal codification.
It did. After a few smaller steps, like a joint declaration in 1975, the principles were finally enshrined in the Treaty on European Union. The current Article 6 TEU, post-Lisbon, outlines what we could call the modern triad of protection.
Okay, let's break down that triad. What are the three pillars?
Right. So, Pillar 1. The Charter of Fundamental Rights, the CFR-EU, which now has the same legal value as the treaties themselves.
So it's primary law.
Primary law. 2. The explicit obligation for the Union to accede to the ECHR. And 3. The continued respect for fundamental rights as general principles, inspired by both the ECHR and those common constitutional traditions.
Let's focus on the CFR-EU for a moment, the Charter of Nice. It provided that written list of rights that was missing for so long.
It did, and it's organized into 7 chapters covering everything from human dignity and freedoms to social rights and justice. It gives real substance to the list of rights.
And it also provided clarity, didn't it?
It did. While a lot of the content just reproduced rights that were already established by the court's case law or found in the ECHR, putting it all in writing provided a kind of democratic clarity and accessibility.
Now, this is the essential part for understanding the limits of all this. The scope of application. That's governed by Article 51 of the Charter.
Absolutely vital. If you're revising this topic, this is the rule to memorize.
So what does it say?
It says the Charter applies fully to all the EU institutions and bodies. But, and here's the major restriction, it applies to member states only when they're implementing union law.
Only when they're acting within the scope of EU law.
Exactly. If a piece of national legislation falls completely outside the sphere of EU competence, the Charter has nothing to say about it.
So the Charter doesn't create new powers for the EU. It only governs the exercise of existing powers. How did the CJEU confirm this crucial limitation?
They confirmed it very clearly in the landmark case Ackerberg-Franson. This case concerned a Swedish national facing parallel criminal and administrative proceedings for tax evasion.
Okay.
And the CJEU ruled explicitly that the scope of the charter coincides precisely with the scope of EU law. Because the national law on tax penalties in that case was deemed to be implementing EU law, the charter applied.
But the court drew a clear line.
A very clear line. They stressed that if the national legislation lay outside the scope of EU law, the court has no power whatsoever to examine its compatibility with the charter. It acts like a constitutional satellite. It only orbits where EU law is already present.
This brings us right back to that seemingly straightforward obligation in Article 6 of the treaty. The Union shall accede to the European Convention for the Protection of Human Rights and Fundamental Freedoms.
Seems simple enough.
It seems simple, but it implies an external check on the EU's actions. And the CJEU had already rejected this once before, back in 1996.
That's right, in Opinion 294. And after years of negotiating a complex new draft agreement, one designed specifically to address the court's previous concerns, the ECJ rejected the process again. Definitively, in Opinion 213 in December 2014. And this ruling is, for now, the final word on the matter.
So why the rejection? I mean, given that the ECHR was the very source of inspiration for the CJEU's general principles back in the 70s, why did the court reject the idea of being externally scrutinized by the Strasbourg court?
Well, it all boils down to one thing. The CJEU's fierce defense of its institutional creation, the autonomy of EU law. The court viewed the draft agreement as posing unacceptable risks to its unique legal architecture.
Okay, let's break down those red lines.
Right.
What specific threats did the CJEU actually identify in the opinion?
Firstly, just the sheer threat to the fundamental autonomy of EU law itself. The CJEU asserted that having the Strasbourg Court review EU acts could threaten the necessary link between EU law and the Charter, the very system the CJEU had invented.
So protecting its own creation.
Exactly. Secondly, there were risks to the EU's institutional balance. The draft agreement could have forced the CJEU to rule on whether a member state had violated the ECHR when implementing EU law, which could draw the CJEU into interpreting the ECHR beyond its normal competence.
It sounds a bit like a turf war over interpretation.
It was, and that leads to the third and most critical point, a threat to the exclusive jurisdiction of the CJEU as the final, supreme, and only interpreter of EU law.
So they didn't want an external body second-guessing them.
Precisely. The CJEU feared that having the ECHR in Strasbourg interpreting EU measures would undermine the uniformity of EU law across all the member states. And fourthly, and this is very practical for internal cooperation, there were concerns about maintaining mutual trust within the EU system.
That mutual trust point is fascinating. We see it used in critical mechanisms like the European arrest warrant.
The EAW is the perfect example. If ECHR accession allowed national courts to challenge the EAW based on ECHR rights, that would completely disrupt the fundamental assumption that all member states automatically trust each other's legal systems.
So the CJEU was basically defending the self-contained legal order it had spent decades building.
It was. It preferred to maintain its own internal centralized control mechanism, the general principles and the charter, over allowing external oversight by the ECTHR.
So the result is clear. No accession. We're left with this dual system of protection. We have the CFR EU operating strictly inside the EU framework and the ECHR operating outside. How does the legal order make sure these two systems operate harmoniously?
Harmony is enforced through a specific legal linkage. Article 52, paragraph 3 of the Charter.
And what does that do?
This article ensures that any rights in the Charter that correspond to ECHR rights must be interpreted to offer at least the same level of protection as the ECHR.
So the ECHR sets the floor.
It sets the mandatory floor, the minimum standard, including all the case law developed by the Strasbourg Court.
But, and this is the crucial part, the CJEU maintains the constitutional high ground. They stress that the EU legal order is always free to raise the level of protection beyond those ECHR standards.
Correct. The ECHR is a source of inspiration and a floor, but it is never a ceiling. The final word on the legality and interpretation of EU law always remains in Luxembourg. And this brings us to a vital case for revision. Maloney.
Why is Maloney so important in defining this current dual system?
because Maloney defined the relationship between the Charter and national constitutions when it comes to that standard of protection. In this case, a Spanish national was trying to avoid extradition to Italy under a European arrest warrant. He argued that Spanish constitutional law provided a higher standard of rights protection than the EAW system, specifically regarding the right to a second trial.
So the Spanish court wanted to apply its higher national standard to block the extradition, which sounds a lot like the old Solange doctrine coming back.
Exactly the same logic, but the CJEU used Maloney to affirm the absolute primacy and effectiveness of EU law. They ruled that when a member state is implementing EU law, in this case, the EAW framework decision, that state cannot apply a higher national constitutional standard if applying that standard would jeopardize the principle of mutual trust and stop EU law from working properly.
So the CJEU is saying that while the ECHR sets the minimum, once the charter applies, national courts can't use their own higher standards to undermine the whole system. That is a final, powerful defense of uniformity.
It is. It demonstrates that the autonomy defended in Opinion 213 is functional. It's real. The history of fundamental rights protection in the EU is, at its heart, a story of constitutional self-defense.
A pretty good summary.
You have the invention of the general principles to solve the internal crisis of primacy, then codifying them into the Charter, and then using that internal system to fiercely reject external judicial oversight in Opinion 213.
That narrative, from initial silence to self-defense, that really ties everything together perfectly for your revision. The CJEU successfully established that the EU legal order is constitutionally self-contained.
The autonomy is unassailable.
And as a final provocative thought for you to reflect on, despite the CJEU's strong defense of autonomy in Opinion 213 and in cases like Maloney, how might the practical operation of mutual trust and the minimum standards required by the Charter still necessitate deep, ongoing, practical dialogue and coordination between the Luxembourg and Strasbourg courts, even without formal accession? It's a conflict that is legally solved but practically ongoing, something to mull over long after your exam is finished.